Okay, so this is going to be CPLR. I'm starting with Article 2 because Article 1 is not on the test. Alright, disregard the blue light on my face. It's from the fish tank. CPLR 201. An action must be commenced within the period prescribed by this article unless a different time is prescribed by law or a shorter time is prescribed by written agreement. No court shall extend the statute of limitations, period. And I did not remember this. I don't know if maybe it wasn't on, it wasn't on the last test because I didn't have Article 2 on the 2 test. So this says, except as in UCC or CPLR 214-A, when the statute of limitations time is computed from actual or imputed discovery of facts, the action must be commenced within 2 years after such discovery or before the expiration of the period, whichever occurs last. Let's say the statute of limitations is like 5 years. Okay, and you discover the facts and it's after 4.5 years. You don't get another 5 years to sue the person. You now have your clock is ticking. You have 2 years from when you discovered the facts or should have discovered the facts. So if they mailed you a notice saying, hey, I did this, come get me, then you have 2 years to do it. If the statute of limitations, the original one, was almost expired or already expired. 204A. Stay by court or statute, duration is not included in statute of limitations. B. Arbitration stay is limited to 1 year after such final determination. So this is like if you are getting sued and you're like, no, I have an arbitration clause in here. You have to submit this claim to arbitration. But then it turns out that you actually had no right to make the plaintiff submit the claim to arbitration. That period while you are like, oh yeah, you got to submit it to arbitration. That period does not count towards their statute of limitations. But it can't be more than a year after the final determination. The say is limited to 1 year after such final determination. Okay. 205. Okay, so this I should be able to do from memory because I used to have this memorized cold. If an action is timely commenced and terminated in any other manner other than a voluntary discontinuance, a final judgment on the merits, a failure to obtain personal jurisdiction over the defendant, or dismissal of the complaint for neglect to prosecute, the plaintiff, or if the plaintiff dies, his executor or administrator, if the cause of action survives, may commence a new action within 6 months, provided that the previous action was timely commenced and service is effected on defendant within such 6-month period. And then it also notes that if the court dismisses an action, oh my God, only 15 minutes. If the court dismisses an action for neglect to prosecute, that if the court dismisses an action for neglect to prosecute, they have to state their specific reasons why they're, dismissing it for neglect to prosecute. 206. When the demand is necessary, the time is computed from when the right to make the demand was complete. I don't know what that means. Probably neither do you. Just fucking memorize it. Okay, wait, let me start over with this. So let's say the state is going to commence an action for conversion. And if the agency or whoever's holding the property in escrow does not give the state its money or property back, then the time is computed from when the right to make the demand was complete, except in the UCC, which is the Uniform Commercial Code, or in 214-A, when time is computed from the actual or imputed discovery of facts. Action must be commenced within 2 years after such discovery or before the expiration of the period, whichever occurs last. There's a distinction that should be made here, distinction that they make between discovery of the injury and discovery of the cause of the injury. So just keep that in mind. Like when you're reading this, note if they say when the injury was discovered, or if they're saying when the cause of the injury was discovered. It's like just a small thing that I've noticed out here. I mean, in here. All right, 204. Stay by court or statute. Duration not included in statute of limitations. Arbitration stay limited to 1 year after such final determination. So that's when you sue somebody and they're like, no, you can't sue me. You signed this thing that says that we have to submit the claim to arbitration. But then it turns out that there's a determination that says, no, actually you didn't have to submit the claim to arbitration. That determination starts the clock on the 1 year. Because the statute cannot be told for more than 1 year when we're talking about arbitration. But it is stayed pending the determination. I guess it usually doesn't take more than a year to figure that out. So loud. 205. An action is timely commenced and terminated in any other manner, but a voluntary discontinuance, a failure to obtain personal jurisdiction over the defendant, dismissal of the complaint for neglect to prosecute, or a final judgment on the merits, or if the plaintiff dies and the cause of action survives, his executor, administrator, or the original plaintiff can commence a new action within 6 months, and it will be deemed timely commenced if the original action is timely commenced. It also notes here that court must, when it dismisses the action for neglect to prosecute, it must state the reasons that demonstrate a general pattern of delay by the plaintiff. 206. When there's a demand necessary to be made, computed from the time. Okay, so this is when there's a demand necessary. When you, I guess, when there's like a condition precedent, you have to make a demand. The time is computed from when the right to make the demand was complete. This is the exceptions to the demand thing. When the right grows out of the receipt or detention of money by a person in a fiduciary duty, the time when the action must be commenced shall be computed from the time when the person having the right to make the demand discovered the facts upon which the right depends. And where there is a deposit of money to be repaid only upon a special demand, or a delivery of personal property not to be returned specifically or in kind at a fixed time or upon a fixed contingency, the time within the action shall be. Okay, so this is talking about, so this is the war artifacts case. There was this agency or something that had acquired like a shitload of war artifacts, like real historical artifacts that people gave them by like devise, or like left them when they died, and this agency acquired all these artifacts. And the government in 1952 was like, oh, you have these? Okay. Well, you're really just, our opinion is you're holding them in escrow for us. So then in 1996, they demand the artifacts be returned. And the agency's like, no, we're not giving them to you, they're ours. And even if they were yours, that ship has sailed. You would have had to sue us in 1960 something. What happens is this case goes all the way to the Court of Appeals, and the Court of Appeals decides, the Supreme Court should have decided whether or not back in 1952, this was a legal acquisition of the goods. Because if it was, that would activate the state's obligation to make a demand. And if the demand in 1996 was made properly, then that's actually when the statute of limitations would start running, because in that case, there was never like a demand made before. So when they had this property from 1952 to 1996, and the state was clearly aware of it, but yeah, and that actually turned out to be important, because if you're just holding something for someone else, and you, in your opinion, you're like, okay, you know what, this person's never coming back for this, and then all of a sudden they sue you, you're like, what the hell? I didn't mean to like steal anything. You know, like, why am I being sued? They're supposed to demand the goods first. and then you would have the opportunity to return them the money or property and not be sued. So I'm going to do this whole section quickly again because I'm probably going to just edit out all that stuff about the artifacts case, the war artifacts case. Or maybe I'll explain it better in this one. All right, so 206. Computing periods of limitation in particular actions. A, where demand necessary, except provided in Article 3 of UCC, where demand is necessary to entitle a person to commence an action, the time within which the action must be commenced shall be computed from the time when the right to make the demand is complete. When your right to make the demand presents itself, that's when the clock starts running on you. Except that where the right grows out of receipt or detention of money or property by a person acting in a fiduciary duty, the time is computed from when the person having the right to make the demand discovers the facts upon which the right depends. And when there is a deposit of money or property to be returned, not at a specific time, the time shall be computed from the demand for repayment or return. And that is the war artifacts case, where the state sued an agency because back in 1952, they required, the state was aware they required a bunch of property, that was worth around $6 to $10 million because it was historical artifacts. And the state was like, oh, well, in 96, they were like, oh, well, we want it back now. And the agency was like, no. And the state sued, and the case went all the way to the Court of Appeals, and the Court of Appeals basically said that there was an issue of fact here, and that the statute of limitations did not start running until 1996 when the state demanded return of the artifacts. In that, war case, the state was saying that this agency was not the owner of the property, that in fact they were just holding it in escrow for the state, and that's what gave the state the right to make this demand in 1996. The other exception is based upon the misconduct of agent. Based upon misconduct of agent. So if the agent does something and your agent does something and you get sued for it, the time to sue your agent doesn't start running until the final determination against you, the principal, is determined. Other exception is breach of covenant or against encumbrances, and that is computed from an eviction. The other one is based upon a mutual, current, and open account where there's reciprocal demands between the parties. It's computed from the last transaction on either side. Also, breach of warranty of authority. So if you're injured, you're financially injured by an agent that didn't have the right to act on behalf of the principal, your time starts running from when you discover the facts constituting lack of authority. All right, 207 basically says that, okay, I have better notes on this than it's in the book. So a potential defendant is either without the state when the cause of action accrues or within the state when the cause of action accrues, but then leaves for 4 months or more. That statute of limitations is told for the period he's outside the state. If he resides in New York State under a false name, the statute of limitations is told during such time. Note that this period is also excluded from the 120-day service period in 306-B. This does not apply, the tolling thing does not apply if 1, you designated an agent for service, or 2, foreign corporation has officers or people that could be served in the state, or 3, personal delivery within the state is not required for jurisdiction. So an example of that would be if you designate the clerk of the court for service. By suing someone in New York, you've designated the clerk of the court or your attorney if they appear in the action as your agent for service, whether or not you intended to. If you are not required, so let's say you're suing for a matrimonial or something, where I don't think for support or matrimonial you have to serve personally within the state, so that would be an example of the statute of limitations not tolling. Okay, so 208. Infancy or insanity. Just remember that the statute of limitations, if it's 3 or more years for a specific cause of action. It's extended for 3 years after disability ceases, but in no event more than 10 years after the cause accrues. The 10-year thing does not apply to a medical malpractice case where the disability is infancy. And this whole section does not apply to actions for penalty, forfeiture, or escape. I guess those are against the sheriff. 209, wartime. Between commencement of the war/occupation and termination of hostilities is not counted in the statute of limitations period. This applies to residents, non-residents, aliens at war, residents or sojourners in countries the U.S. or its allies is at war with. Does not apply to 625 banking law or against the superintendent of financial services. So if you're suing for something under the banking law there, then the statute of limitations is not hold. 210, death of claimant. Action may be commenced within 1 year after death. This is not a tolling because this is 1 year from death or the original period. Okay, so it's not a tolling. It's just, if necessary, they extend it for a year after death of claimant. Death of person liable. Now, this is a tolling. 18 months after death, this is added on to the original period of limitation, unlike the one with the claimant. 211, 20 years statute of limitations. There is 5 things here. 1, bond. The key here is that the bond is only secured by the issuer's pledge. So there's a bond here, and then there's going to be a bond with a different time rule. And this one, the 20-year one, is when it's like you hear those advertisements, oh, the state or whatever is offering bonds and there's an obligation to pay. Okay? And that does not apply here. There is no statute of limitations on those as far as I know. So if it's a state or federal government bonds, doesn't apply. It's only a bond secured by the issuer's pledge. 2, by the state for real property. 3, by grantee of state for real property. 4, money judgment. 5, support, alimony, or maintenance. And this is calculated from the default in payment. Whether or not there's a money judgment been issued, that's when it's calculated from, a default in payment. 10-year statute of limitations. There are 6 here. So 5 for the 20 years, 6 for the 10-year that I found so far. 1, recover real property by anyone but the state. 2, annulment of letters patent / grant of real property by a state. 3, redeem from a mortgage. 4, recover under an affidavit for support of an alien. 5, by a victim of labor or sex trafficking, SSL 384-BB. And this one is actually in 213-B. This is 6, by a victim of defendant convicted of 632-A sub E executive law, an offense specified there. That's 10 years. 7 years, statute of limitations, is by a crime victim. In this case, a conviction is required to activate the 7-year statute of limitations. So if there's an assault but no conviction, that's got to be under the assault and battery 1-year statute of limitations. If there is a conviction, you get 7 years to sue the person. So this is 213, 6-year statute of limitations. 1, catch-all, when there's no statute specified, it's 6 years. 2, on a contract. The exceptions here are 213-A, UCC Article 2, and 36-B of the General Business Law. 3, sealed instrument. 4, bond secured by mortgage on real property. So this is the difference between the 20-year bond and the 6-year bond. This is a bond secured by a mortgage on real property. 5, action by state for spoliation of public property computed from the time of discovery by the state. 6, mistake. 7, corporation versus director for fraud. 8, fraud, 2 years from the discovery of the fraud. So I'm gonna rapid fire those ones to repeat them. So 211, 20 years. 1, bond. 2, state for real property. 3, grantee of state for real property. 4, on a money judgment. 5, support alimony or maintenance calculated from a default in payment. 212, 10-year statute of limitation. 1, recover real property. 2, annulment of letters patent. 3, redeem from a mortgage. 4, recover under an affidavit for support of an alien. 5, victim of labor or sex trafficking. 6, victim of convicted. 632, executive law. 7 years is for a crime victim other than a sex crime. It's calculated from the date of offense, but if there's a conviction, anything but a sex crime gets 1 year additional after the conviction to sue. Sex crime gets 5 years after the conviction. 213, 6-year statute of limitation. 1, none provided, catch-all. 2, on a contract. 3, sealed instrument. 4, bond secured by mortgage. 5, action by state for spoliation of public property. 6, mistake. 7, corporation versus director for fraud. 8, fraud. 2 years from discovery. So this is 213-C, and in this one, this is an important distinction because no conviction is required to activate the 5-year statute of limitation. So this is for a rape, a criminal sex act, course of sexual conduct against a child, and aggravated sexual abuse, all in the first degree. You get 5 years statute of limitation, and it only is against the person that could be convicted of the offense. So either a co-defendant or the defendant himself, not like the university or the restaurant that you worked in. You can't go back 5 years after the fact and sue the restaurant or the university and say, you should have like protected me better. You would have had to do that within whatever statute of limitations it says in the regular law. 4 years statute of limitations. Residential rent overcharge within 4 years of the first overcharge alleged. 214, 3-year statute of limitations. 1, against sheriff for non-payment of money collected on an execution. 2, a penalty created by statute. 3, recover a chattel. 4, injury to property. 5, personal injury. 6, malpractice other than medical, dental, or podiatrics, so like legal malpractice. 7, annul a marriage on the ground of fraud. 8, superfund site measured from the date the site was designated as a superfund site or the discovery, I guess, of the injury. And a note here on the injury to property and personal injury, exposure causing injury to person or property is calculated from discovery of the injury. If the cause is discovered within 5 years, the plaintiff can sue within 1 year. So medical, dental, and podiatric malpractice is 2 years, 6 months statute of limitation. 214-A. 214-C, certain actions to be commenced within 3 years of discovery of injury does not apply to medical or dental malpractice. Podiatrics not in that one, but whatever. Agent Orange is a 2-year statute of limitation. So then 214-D, I don't know if they would ask this, but it's got a lot of information here and it's got a couple of time rules. So this is about like if you're suing like a licensed architect or a surveyor or something, and it's been more than 10 years since that person designed the building or whatever. If it's been more than 10 years, upon the filing of you have to file a notice of claim prior to suing, 90 days prior to suing, give written notice of the claim to the architect. Upon filing the notice of claim, county clerk shall collect a fee and assign an index number, and you have to file the notice of claim that you served with the affidavit of service within 30 days of actually serving it. Then when you file it, you pay the fee, you get an index number. A note here says no fees for cross-claim or third-party claim are allowed under this section. The plaintiff/claimant shall have the right to like ABTs and discovery. Architect must comply. Architects may make 3211 or 3212 motion, which shall be granted unless plaintiff proves or, demonstrates that there was negligence and it was negligence caused by the architect or whatever, and that was the cause of the injury or wrongful death. And this motion shall be granted if he doesn't prove those things, and the court shall grant a preference. There's statutory preference in hearing of those motions. This section is like an exception to the regular statute of limitations because they're talking about a 10-year thing here. And normally injury or wrongful death has a 3-year statute of limitations. Service of the notice tolls the statute of limitations and also the 120-day service period. This is, like I said, this has got a lot of information in it. I didn't go over it all, but I don't know if they'll get into that. And if they do, they're probably going to ask something about the 90-day rule or the 30 days, or you're going to have to know about the 10 years. 215, 1-year statute of limitations. This is 215. 1. Action against sheriff, constable, coroner, except for non-payment of money from execution, because that's a 3-year statute of limitation. 2. Escape of prisoner arrested on a civil mandate. 3. Assault, battery, malicious prosecution, libel, slander, violation of right to privacy, false words causing special damages. 4. Penalty given to informer, enforced penalty or forfeiture. However, if not done by private person within 1 year, state can do it within 3 years. 5. Collect an arbitration award. 6. Overcharge, enforced penalty on overcharge of interest. 7. Action by tenant. 223-B sub 3 of real property law. 8. 1 year after termination or conviction, except for sex crimes in first degree. 5 years after termination of criminal action. So let me do those again. This is the 1-year statute of limitations in CPLR 215. 1. Action against sheriff except for non-payment. 2. Escape of prisoner arrested on civil mandate. 3. Assault, battery, malicious prosecution, libel, slander, violation of right to privacy, false words causing special damages. 4. Penalty given to informer, enforced penalty forfeiture. 5. Arbitration awards. 6. Overcharge of interest. 7. Action by tenant. 8. 1 year after termination of criminal action, you could sue the person. Oh, I was definitely up to 215. My little doggy's here. He's so cute. He wanted some love. Okay, so 216 is saying that you cannot, if you get a notice that there's already an action pending for the money that you wanted to sue for, you get a notice, even if the court didn't have jurisdiction over you, you cannot go and sue that New York defendant for that money because it's been a year past and you had a year to intervene or start a new action for that same money if you were the claimant. And that is going to be explained further when I actually get into the stuff about the claimant. And the 1 year thing, the action is pending for an order allowing him to notify this other claimant that this lawsuit is pending and that it's the same money. Oh, baby, you have water? All right, so this is 216 sub 2. If any person shall make claim for the recovery of any sum of money due and payable under an account or contract, and an action has theretofore been or shall thereafter be commenced by another person to recover the sum exceeding $50, the defendant in such action may, within 20 days from service upon him of the complaint or from the receipt of him of the claim, whichever occurs last, he can make a motion to the court where the action is pending for an order permitting defendant to give notice to this other claimant that the action is pending. The court shall grant the motion where it appears that a person not a party to the action has made claim against defendant for the same money exceeding $50 in amount or a part thereof, and that the action was brought without collusion between the defendant and the plaintiff, and that the claimant cannot, with due diligence, be served with process in such a manner to obtain jurisdiction over his person. The order shall provide that notice be given to the claimant by sending a copy of the summons and complaint by registered mail or If there's no registered mail wherever he is, then by regular mail. On such terms as conditions as order may direct. Proof that the notice has been mailed shall be filed within 10 days from the date of the order. Otherwise, the order becomes inoperative. Upon such filing, notice shall be deemed to have been given on the 10th day after the date of such order. Well, that doesn't make any sense, because if you have to mail it within 10 days, he's not going to get it within 10 days. Anyway, upon proof of affidavit by otherwise, the satisfaction of the court that the conditions have been satisfied and that there is no collusion between the claimant and defendant, the court shall make an order staying further prosecution of the action for a period not to exceed 1 year. The stay shall be lifted upon proof by either party that the claimant has brought a new action in any court of the state or has intervened in the action that's already pending. At the time of granting such order or any time thereafter, the court, upon the motion of any party, shall, as a condition of the order, impose upon the defendant such terms as justice may require as to the furnishing of an undertaking in an amount to be fixed by the court. The stay shall be vacated, the undertaking discharged upon proof by any party, the claimant, that the claimant has intervened in the action or sued the defendant in another court of the state. A motion for any relief shall be made on notice to other parties in the action. So the defendant makes his motion, has to be by notice of motion. It can't be by order to show cause. Whenever claims are made by 2 or more persons, each claiming to be to the exclusion of the other, the duly authorized deputy or agent to demand, receive, collect, sue for, or recover the same money due and payable under or on account of a contract exceeding $50, and on behalf of the same person, each person making such a claim shall be deemed an adverse claimant. Notwithstanding that an action has been commenced in the name of or on behalf of the purgent, oh my God, this is great. It says, notwithstanding that an action has been commenced in the name of or on behalf of the person for whom he claims to be the authorized agent, any such adverse claimant may be notified of the pendency of an action as provided in this subdivision and may intervene in the action and be designated as claiming to be or as the alleged deputy officer or agent. What? Oh my goodness. Okay. I'm going to have to break that down and get back to it. 6. Whenever an action has been commenced for the recovery of any sum of money exceeding $50 and payable under an account or on a contract, and the records of the defendant show that a person other than the plaintiff has the right, exclusive of other deputies or agents of the plaintiff, to demand, sue for, and recover the same money, either in his own name or on his own behalf, or as the authorized agent of the plaintiff, and the defendant has received no notice of transfer, revocation, or other change in right or authority acceptable to it, the person so appearing on the records shall be deemed to have made an adverse claim to the sum of money and may be treated as an adverse claimant. Action to recover property. This basically says the same thing. They're treated as an adverse claimant in which the action is pending, has no jurisdiction over the adverse claimant, to direct the issuance of process, or if the same be issued, it would be without effect, notwithstanding the action seeks to have declared, enforced, regulated, defined, or limited rights upon specific personal property within the state. The defendant within the action may, within 20 days after date of service, or 20 days of the receipt of the adverse claim, whichever occurs last, he can make a motion to the court for leave to give notice in the same way as the other section. And then upon granting of such order, the provisions of sub A shall apply insofar as they are compatible with the subject matter of the action. 217. Unless a shorter time is prescribed, a proceeding against the body or officer must be commenced within 4 months after the determination to be reviewed becomes final and binding upon the petitioner or the person he represents in law or in fact, or after the respondent's refusal upon the demand to perform its duty, or with leave of court where the petitioner or the person whom he represents was under a disability within 2 years after such time. So that is an exception that I did not memorize when I studied for the test the first time. It's a 4-month statute of limitations, but when the person is under a disability, 2 years. Specified in 208, which is infancy or insanity. There's 2 years. Okay, an action against your union for breach of its duty, 4 months. Action against an employer pursuant to the labor law or civil service law shall be commenced within 4 months of the date the employee knew or should have known the breach had occurred, or within 4 months the employee actually suffering harm, whichever occurs last. All right, this is a weird one. I don't know when. Oh, this is from 2013, so I didn't know. I didn't have to know it before. This is 217-A. Actions to be commenced within 1 year and 90 days. Notwithstanding any provision of law or the contract, and irrespective of whether the relevant statute is expressly amended by Uniform Notice of Claim Act, every action for damages for injuries to real or personal property or destruction thereof, or personal injury or wrongful death against any political subdivision, any public authority, or any public benefit corporation that is entitled to receive a notice of claim as a condition precedent to commencement of an action shall not be commenced unless a notice of claim shall have been served on such governmental entity within the time limit established by 50-E of the General Municipal Law, and such action must be commenced in compliance with all the requirements of such law, and 50-I of the General Municipal Law, except in an action for wrongful death against such an entity, an action for damages to injuries to real or personal property or destruction thereof, or personal injuries alleged to have been sustained shall not be commenced more than 1 year and 90 days after the cause of action, therefore shall have accrued or within the time period prescribed by 2 in the morning right now, I think. Any special provision of law, whichever is longer. Nothing herein is intended to amend the Court of Claims Act or any provision thereof. So basically, if you're going to sue a governmental entity and you have to serve a notice of claim on them, you have 1 year and 90 days. And it doesn't matter whether the relevant statute is expressly amended by the Uniform Notice of Claim Act. You have a year and 90 days. 218 says actions barred at effective date. Nothing in this article shall authorize any action to be commenced which is barred when this article becomes effective, except insofar as the right to commence the action may be revived by an acknowledgement of payment. B. Cause of action accrued and not barred at effective date, where a cause of action accrued before and is not barred when this article becomes effective. The time which an action must be commenced shall be the time which would have been applicable apart from the provisions of this article, or the time which would have been applicable if the provisions of this article had been in effect when the cause of action accrued, whichever is longer. And that is a wrap of Article 2.